So hi everyone, good morning. My name is Urshila and I'm a senior data protection consultant here at SARO. For today's topic, we'll be discussing data protection in practice. So just a short introduction about myself. I'm CIPPE certified and I'm also a certified DPO. Apart from that, I worked on multiple projects with clients, both startups as well as MNCs that have dealt with GDPR implementation as well as implementation of other privacy laws, such as the CCPA, the Malaysian law, and the Singapore PDPA, just to name a few. So that's just a little bit about myself. So as a part of our data protection in practice session, what we're going to be discussing is two very important principles of the GDPR, or two important concepts under the GDPR, which is data protection by design and by default. And the other concept that we'll be discussing, or another practice that is extremely important under privacy that we'll be discussing, is data protection impact assessments. So we'll start out by discussing data protection by design. So Article 25 of the GDPR deals with something called data protection by design and by default. So clause 1 of Article 25 deals with data protection by design. So what does this mean? So this means that privacy has to be embedded into products or technology or any kind of process that you're developing at the design phase itself. So as you can see, there are a couple of pointers on the presentation. So what that means in practice is that privacy elements have to be present in your designing of the particular technology. So you can do so by using privacy enhancing technologies. That's one way to go about it. And it also means dealing with privacy issues that might arise from the very start. The main benefit of embedding privacy by design into your product at the very initial stages is that it ensures compliance with the core principles of privacy at the design phase. So it can save you a lot of money in the long run. So instead of making changes post being brought up by a regulator saying that you haven't complied with privacy, your product or your device is already compliant with privacy at the very initial stages. So you do not have to make any changes or amendments to the code or to the technology post implementation or bringing it into the market. So that's one of the benefits of data protection by design or privacy by design. So just an example of what privacy by design is. So privacy by design includes things like using of encryption. So some people might be a little bit confused that this is an overlap with security. But as most privacy professionals know, that privacy and security both go hand in hand. So that's why we talk about security principles as well. So so an example here is encryption. So using of encryption technology, say when you are transferring sensitive personal data or when you're storing sensitive personal data on a device, this could be an example of privacy by design. Another example is using pseudo-anonymization. So as the name suggests, that it doesn't mean complete anonymization. What it means is substituting personal information or PII with artificial identifiers so that you cannot enable direct identification of a person. So that's what pseudo-anonymization is. So we can move on to the concept of data protection by default. And so data protection by default is a principle that's been dealt with under Article 25, Clause 2 of the GDPR. And so what it says is that privacy should be embedded into your product or your process by default. So so what this means is that when you design your product or your technology or your application, say for example, then you keep privacy at the forefront and then you design all of your processes. So it's really putting the consumer or the user's privacy first. So that's what it means in layman's terms. So data protection is it's a privacy by default. What that means is that it's a user first approach at the core of development. And so this should be done whenever you determine the purpose of processing, which is specific to each user activity. That's just a brief of both of the concepts of data protection by design and by default, which is dealt with under Article 25. So moving on to an example of data protection by default. So an example of this would be your default security features or your privacy features on, say, an app, something like Facebook. So if you, for example, make sure that a user's profile is actually private by default as soon as they download the application, and only if they want it to be public, then they can turn on the public feature and then their profile becomes visible to everybody else. So this is a case in which you would actually have privacy by default. So another example that I can give you guys is when, say, for example, most applications now require your location data. So if by default, when a user actually downloads the application, you don't actively track them, but you ask them for permission to turn on their GPS, and only then you track them, this would be a privacy by default setting. So these are just some examples of privacy by default. So moving on, we'll also be looking at why companies should incorporate data protection by design and by default. So the main purpose is that it protects individual privacy. And we see in today's world that privacy could be a USP for a lot of companies. Like Apple has made privacy a USP. So this could be extremely beneficial for companies in the long run as well. Apart from that, another real benefit of incorporating privacy by design and by default is that it's a cost-effective solution for protection. So like I had previously mentioned, why is it cost effective? So most companies view privacy compliance as a heavy financial burden. However, it could be extremely cost effective in the long run because privacy is being incorporated at the very development phase of a particular product or technology. The likelihood of being brought up or being penalized by a regulator later on for violations of the GDPR or various principles of privacy is unlikely. And so it would save regulatory costs. So that's why we consider embedding privacy by design and by default as a cost-effective solution for companies in the long run. So the third benefit that we'll be looking at is that there's data security measures that are implemented at an early stage. So data protection or privacy by design and by default also looks at the security measures that have been implemented in a particular application. So so what happens is that it not only looks at privacy principles like accountability and transparency, but it also looks at security measures such as encryption, how is the data being stored, where is the data being stored, is there a backup of the data being maintained? So things like this are also looked at in data protection by design and by default. Another benefit is that it establishes accountability, and also there's privacy from the very beginning. Moving on to who is actually responsible for compliance with privacy by design and by default principles. So actually the GDPR specifies that controllers are responsible for ensuring data protection by design and by default. So the GDPR doesn't mention that processors are actually responsible. So who are controllers? Controllers are those who decide the purpose of processing of the data. And so that's just a very short brief of who a controller is. And so the GDPR specifies that it's the controller who's actually responsible for incorporating data protection by design and by default. They actually have to take into account certain factors while also choosing a processor. And this is linked to Article 28 of the GDPR, as well as Article 32 of the GDPR, which imposes security duties on the controller as well. So it's the duty of the controller to impose certain obligations if they are using processors to implement data protection by design and by default. So the GDPR doesn't mention, or there's no law that actually mentions that developers or designers who create the technology or the applications are under an obligation to design or build in privacy principles into an application. So at the end of the day, what we can take away from this is that Article 25 only places an obligation on controllers to comply with the principle of data protection by design and by default. Before moving on to data protection impact assessments and how that's very important for an organization, I'll also be dealing with how in practice can we implement data protection by design and by default. So both of these principles might actually appear to be extremely daunting to people because they're just concepts that are described under GDPR, and it doesn't really tell you how to implement it as such. In practice, what we do to implement privacy by design and by default is to actually do a privacy by design and a default assessment. So what that actually entails is looking at 7 core principles that were laid down by the Information Commissioner of Ontario, that's Canada. So she mainly dealt with 7 principles of privacy. And based on these principles, we do a certain assessment of a number of controls that have been created, and we test whether privacy has been incorporated at the design phase. So when do we do a privacy by design and by default assessment? We can do a privacy by design and default assessment at 2 different stages. So the first stage at which we can do a privacy by design and default assessment is actually when the product is being developed or created. So of course, this is a very idealistic scenario. So the second phase in which we can actually do one is once the product or the technology has already been created and it's been introduced into the market. And also we can also do an assessment at that point in time. So the main purpose of doing that assessment would be to understand where the product or the process stands in terms of privacy. We can also look at the risks that are present in the particular application and try to mitigate these kind of risks that are present. So what's also important for companies to ensure that privacy by design and by default is being incorporated at the design phase, or that your developers and your designers are actually incorporating privacy, is that firstly, you can use your SDLC policy as a kind of framework and embed these privacy controls or these privacy principles as a checklist into the SDLC policy. So what that will do is that it will provide guidelines to your developers and your tech team to incorporate privacy into the entire development process. So along with that, simply incorporating privacy principles or privacy controls into your SDLC policy is not the only step that you can take or the only step that you should take. It's also important to have training and awareness sessions for your tech team so that they are aware of why the company wants to incorporate privacy by design into their technology and why it's important for users and their consumers of the product. This is how we usually ensure that companies comply with this principle of privacy by design and by default. So the next thing that we'll be looking at in this session is actually the data protection impact assessments. So or we also call it privacy impact assessments, PIAs or DPIAs. So what is a DPIA? So a DPIA is a risk management tool, and it's been referred to in Article 35 of the GDPR. A data protection impact assessment is very different from, say, a privacy by design assessment. So a data protection impact assessment is mainly done in order to assess the risks that are present to data subjects. So, or to data subject rights as well. So that's the main purpose of a data protection impact assessment. When do we actually, or why do we do a data protection impact assessment? So a data protection impact assessment, like I was saying, is something, or a PIA is something that's been mentioned under Article 25 of the GDPR. So when do we actually do a data protection impact assessment, or why do we do a data protection impact assessment? So a privacy impact assessment is done when there's systematic and there's a large scale processing of personal data. So in this case, we do a data protection impact assessment in order to analyze, or in order to understand the privacy concerns or the privacy risks that are existing. So in the particular process. So it's not a compliance risk specifically, but it caters to larger risks or the rights and freedoms of data subjects. So that's the main purpose of doing a DPIA or a privacy impact assessment. So it focuses on both the possibility or the likelihood of a risk taking place and the severity of the impact on a particular data subject. So it also tries to tell you the potential privacy risks that might arise and the possible measures that you can take to mitigate these risks. So it focuses on all potential nature of harm. It focuses on both physical material and non-material harm. Moving on, so the triad of DPIA. So there are three main concepts that are covered under a DPIA. So it looks at necessity, legality, and periphery. So necessity, what that means is that it's not necessary for a DPIA to state that all risks have been mitigated or eliminated. So like I mentioned, the main purpose of a DPIA is to actually understand the risks to data subjects. And the main purpose of doing a DPIA is to understand the level of harm that would take place to a data subject. So what companies can do as a result of after doing a DPIA is to categorize the risks as, say, high risk, low risk, and medium risk. And so depending on the category or the level of risks that are present to data subjects, and depending on this, you could take certain actions to mitigate these risks, or take certain controls and implement them in order to mitigate the risks. So a certain risks that are categorized as, say, high risk could be mitigated first. So say, for example, one of the risks could be that data from the EU or EU citizens' sensitive personal data is being transferred to countries like India, and there's no SCCs or BCRs or any kind of protective measures under the GDPR that has been signed or that's being used by the parties. So in that case, this could be a high level risk to data subjects, and also in terms of compliance. So certain measures could be taken to first mitigate this risk. The second aspect is legality. So a DPIA is done for processing that is likely to be a higher risk. So again, high risk here means risk to data subject rights and freedoms, or so it's a legal necessity under GDPR in this case. So this would vary from a case-to-case scenario. So the main threshold or the main criteria on which you would determine whether to actually do a PIA or a DPIA is to first understand, does the particular process actually use personal data or sensitive personal data that might cause a risk to data subjects. The next concept is the periphery. So a DPIA can be for a single processing activity or for a series of activities that are comparable and can be performed by a group of controllers. So what we suggest to companies is usually to do a DPIA for a single processing activity at each time, because this would give them a better idea or a clearer idea of the risks that are present in a particular processing activity. So say, for example, under the marketing department, you would have sending mass mailers, or you could have generating leads. Sending of mass mailers could be one particular process on which you conduct a DPIA in order to find out the risk to data subjects. So one of the risks that you might have identified is that proper consent is not being taken, or that there is no unsubscribe option that's being given to consumers in the emails that are being sent out. So the GDPR also specifies certain circumstances in which you have to conduct a data protection impact assessment. And these are some of the cases that we've pointed out here. So some of the cases would be when developing new technologies, when you're using extremely intrusive measures in terms of privacy, such as tracking user behavior, when user behavior is being tracked publicly through publicly accessible data on a large scale. So another case in which you would have to conduct a DPIA is when there's processing of sensitive personal data. And also when data of minors or children is being processed, then a DPIA has to be conducted. The next case in which you would have to conduct a data protection impact assessment is when processing involves automated decision making. And the last case in which you would have to conduct a DPIA is when processing could result in physical harm to the subject, or when there's any sort of risk or very high risk to data subject rights and freedoms. That is when a PIA will have to be conducted. So what are the benefits of actually doing a data protection impact assessment? So the main purpose of doing a data protection impact assessment is that you can avoid any sort of fines that may be imposed on you as a result of non-compliance with the GDPR. Another purpose of doing a DPIA is that it can improve public confidence, or it can improve your user trust or consumer trust. Certain companies also, after they do a data protection impact assessment, they actually put out their reports of the data protection impact assessment that would highlight the risks that were found out and the kinds of measures that they were taking to mitigate these risks. So you could find data protection impact assessment reports of companies like Zoom as well. That is public, and everybody can read these reports because they actually want to improve user confidence or public trust. The next benefit is that it is a protection of user data rights under the GDPR. So like I previously mentioned, the main purpose is to actually understand the risk to data subject rights. So by implementing certain controls to mitigate these risks that were previously found out through the data protection impact assessment, there's a protection of user rights or mitigation of any sort of risk to these rights. So a data protection impact assessment also reduces the company's data security issues. So it could also reduce the likelihood of a data breach taking place, because you could be using greater security measures. Say, for example, that the databases on which passwords were being stored are now being encrypted. So, and the last benefit is that it optimizes information flow within a project. So what this means, the last point, is that when doing a data protection impact assessment, the first step to actually take is to understand the data flow in an organization, or the data flow in a particular process in which the DPIA is going to take place. So initially you would either create a data flow diagram, or you would create a sort of ROPA document on the basis of which you would then conduct a data protection impact assessment. So a data protection impact assessment can also be very beneficial in terms of giving the company an overview of the kind of data that's being collected and where the data is being transferred. So this is just some of the benefits of doing a data protection impact assessment. So like every other session, there's also a quiz. So you can scan the code and participate in the quiz. So if you scan the code, you can also get your certificate of participation along with actually taking the quiz. So taking the quiz will help you actually see what you've learned from this session and taken away from this session. So I think one of the questions in the chat was that, do we have a DPIA template? So yes, we actually have a DPIA template, and I think that's available through one of our previous sessions that we've held, or it's available on our website. So I will actually share the link to the DPIA template probably at the end of this session, if possible, or if you can visit our website, there is also a number of templates that are available, and you can access the DPIA template from our website.